But he sells the company. Should he sell it before or after he leaves California and comes back to the UK?
Well, I mean, if that's a realistic, I mean, I hate always to say that, don't let tax determine your life, but if that's a real possibility, if we, as a tax planner, if we could time it such, that he could actually come to the UK and the sale could happen in the UK, then there's so much planning which could be involved. I mean, just to list them out, I mean, if he does nothing, he's paying 20% in the UK versus 36% in California. But there is more that can be done. We could be looking to claim entrepreneurs relief at least on $1 million. We could be doing planning now so his wife gets entrepreneurs relief on $1 million. We could think about whether his wife could claim the benefit of non-dom status and she could own the shares when they sell them in the UK. We could think about whether he could be non-resident anywhere, leave the US but not trigger UK residence under the statutory residence test. And because he's been out more than 5 years, he's not subject to the temporary non-residence rules. Or we could even do some more aggressive planning, which looks at the difference in the taxation point between UK and US rules, whereby UK look at the point of exchange typically, while the US look at the date of completion as the taxing points. And if you sort of have exchange in the US but completion in the UK, you can potentially argue that neither event is taxable. So there's, in simple terms, he should sell after he leaves.
Okay. I think the plan is to stay put in California for the time being, but his US attorney has suggested he should transfer all his American assets into a living trust, so including his shares in the US company. And she's drafted a trust document that is about 130 pages long. Now, I love trusts, and I love looking at trust documents, but ones that are 130 pages long and written in American and include all sorts of pour-over provisions, exempt provisions, they are incredibly complicated. At the end of the day, this is a living trust, of which he and his wife are going to be the trustees. So how they will administer it in accordance to terms of the trust, I'm not entirely sure. But then I'm a UK biased trust lawyer, and the Californian lawyer, she says this is what everyone does in the US, and it's very necessary to avoid US probate. And then also she says as a grantor trust in the US, the creation of it is tax neutral, so it has no tax consequences. But John is still UK domiciled. He intends to return to the UK, so he won't have acquired a domicile of choice in California. And under the US-UK double estate tax treaty, because he's only been resident in California for 5 years, so fewer than 7 out of the past 10 years, he's treated as UK domiciled. So under the treaty, he will still be subject to UK inheritance tax on his worldwide estate. And the US can only tax his real estate situated in the US. So if the living trust is more than just a bare trust for UK tax purposes, which it probably is because the trustees have got some dispositive powers, but qualifies for grantor status, then any transfer of assets into that is going to be an immediately chargeable transfer and could potentially be taxed at 20%. So putting his shares into the trust could trigger quite a large tax liability unless we can claim business property relief in the UK.